This is Reddy. We are live here from Houston, Texas. Every Tuesday, we bring in immigration updates live from between 5 to 6 p.m. Central Time, and we take live questions. Emily, what do we have discussed today?
Today, we want to talk about the B2 visa for visitors, and is it a good option if you are on H-1B and are laid off and are nearing your 60-day grace period? Is filing a change of status to B2 going to work? We're also going to talk about the H-1B lottery. We know there's a lot of fraud that's been happening over the last number of years, but it's really gotten out of control this year. So if you are aware of a company who is doing this fraud and filing these duplicate registrations, conspiring with other companies, how can you make a complaint against them, and why should you do that? And then we'll talk about the EAD and AP renewal timeline. Generally, we file those 120 to 180 days in advance. But with long processing times, is it possible to file it even before that? And what are the potential issues that come up if you file it early? And then lastly, with the priority dates where they are, the dates are not moving. We're kind of back to how things were before October 2020. A lot of people are coming to the realization that they may never get a green card. If nothing changes in Congress or they don't recapture these unused green cards, by the time a green card becomes available, people will have died or retired, or they're not going to be able to. So if knowing that, what is the point of starting the green card process? Should you still file the PERM? Should you still file the I-140, even if you think you may never get the green card?
Emily, coming to the first topic, when the people get laid off on H-1B or L-1, they do have an option of going outside the country. Of course, especially for the people who are on H-1B, they're contemplating, maybe they want to spend some time in the United States. And maybe when they spend some time, they may want to change the status back to H-1B. Previously, when people used to change to B1, B2, and they want to change the status to H-1B, most of the times we didn't used to get the H-1B approval because the USCIS used to say that since your B2 is not approved yet, we are not going to approve the H-1B. Now, is there any change on that right now from the USCIS, Emily?
Yeah, they do have a new stance on that. So if you're in the situation where you have been laid off, the 60-day grace period has come to an end, and you need to continue to stay in the U.S. for up to 6 months while you continue your job search, you file an I-539 application to change your status. When you do later find that H-1B role and the company files the H-1B petition, USCIS is now saying that if you file that change of status from the B2 that you don't have approved yet back to H-1B, and it's done in premium processing, that they will automatically adjudicate the B2 change of status at the same time. So they'll take you from H-1B to B2 back to H-1B all in one step. And so that is a big relief, because before we were stuck with the idea of once you file that B2 and stay for your 6 months, there's no way to get back into any other status except for leaving the US and applying for a new visa at the consulate. So now people are able to continue to stay as long as they find that new role within the 6-month window that they've requested on the B2.
Emily, on the USCIS tweet, though, they only said that they're going to do that with B2. What if I have an H4 option and I apply for H4 instead of B2, which probably is a better option being an H4? The same thing to change from H4 to H1, even if the H4 is not approved, do you expect them to approve H4 and H1B at the same time if I do in premium processing?
Yeah, so we do normally in our petitions like that, we'll specify that the H4 change of status is still pending. We provide that receipt number, provide a copy of the receipt notice, and we request USCIS to please adjudicate the H4 change of status at the same time of the H-1B so that the person can remain in the country. And we have had success in doing that. It's unclear if that success was just because of the COVID situation and USCIS knew they couldn't really send people abroad during that time. But it's the same idea. So I don't know why they would only do it for B2s and not do it for other changes of status that people qualified for.
So yeah, we expect the same result coming from H4. Also, if you have an option of H4 or B2, we strongly recommend going for definitely applying for H4, which is long term and shouldn't have much problem moving from H4 to H1. That's a very good. We welcome the development. We welcome the tweet. Hope so USCIS will keep up its promise. Emily, with regards to the fraud that's going on, we realize that a lot of the people got stuck with this fraud, and we're receiving notice of intent to revoke. We're receiving notice of intent to deny every day, a lot of consultations in the daily conference calls, and people are reporting. What are the ways that when some people find that a fraud has been done by a H-1B company, does our office provide any help in helping the individuals complain against the companies to the USCIS?
So I think as far as the complaint, it's usually driven by the individual because they have the knowledge and can easily submit that information to USCIS. It's just an email address that they would send and just provide whatever information that they can. As far as if these companies also requested money for submitting these multiple registrations, then we have a potential violation of the H-1B regulations, because the employer is not supposed to be asking the employee to pay for their H-1B process. And in that situation, we do help individuals to basically demand that money back from these companies. Otherwise, a wage and hour complaint will be submitted through the Department of Labor. And hopefully at least to get the employee's money back, even though they can't proceed with the H-1B. In some way, they're able to be made whole. What other options do people have?
Yeah, we have given a link, guys. If you want to complain against a company, please go ahead and complain it. The link is directly to the USCIS website. There is a H-1B employer fraud, particularly. There is a separate web link given by the USCIS. But when you do complain, though, just don't complain. Oh, I know about this company is doing fraud. I already see Mr. Ramchandra Reddy is saying that he's been reporting for past 2 months and no action. Well, USCIS or the Immigration Customs Enforcement, they're not that quick. They'll take a little bit of time for them. They're going to look into your complaint to see if it's something worth it they want to proceed. When you complain about a company, though, give the specific detail. On this day, they have filed the case for John Doe, okay? And give the details of that person. If you know the date of birth, if you know anything, give it to them. Give all the details to them. Look, this is the information. Let's say, for example, if they have taken your passport and your information, and they have given your passport information to a lot of other people, that definitely is something that you can complain, because now if your name is involved in filing multiple applications, you may be hit with a permanent bar coming into the United States. So you have to take action in front so that you may protect yourself at a later date. Look, I was not aware of it. When I became aware of it, I did complain to the USCIS, and you can keep a receipt of it. So it may protect you at a later date if the companies have done fraud without your knowledge. So yeah, it will take time. I still want you to guys complain against the companies. Don't complain against all consulting companies. Not all consulting companies are bad, but there are definitely some consulting companies that are rogue consulting companies that are bringing very bad name. We should complain against. When we do complain, we should complain very specific details. Anything else, Emily, before we go to the experiment that you have done on EAD and AP filing before 180 days?
Yeah, we can go ahead to that topic.
First of all, EAD and AP, it's very clear guidelines from the USCIS website is that you can only file within 180 days. So if my EAD is expiring in, let's say, for example, November of 2023, I can file the extension right now. But what if EAD and AP? What if my EAD and AP extension is expiring in April of 2024, which is 11 months from now? Can we file the extension? Because these people are taking 11 months or even more than that to approve an advance parole.
Yeah, the real issue is the advance parole, because we know with the EAD renewals that you have right now the automatic 540-day extension of the EAD. So that gives you that extra time to wait for the EAD to be approved, and you still can continue to work. That's going to reduce down to 180 days I believe that September 30th of this year is the end date for that. But 180 days, that's an extra 6 months. So basically, as long as they process your renewal within a year for the EAD, you're not going to have any gap in your employment authorization. But the AP is the big problem because that processing time is about a year. And there is no automatic extension of it while the renewal is pending. So while you're waiting for your new one to come in, you have no ability to travel unless you continue to maintain your non-immigrant status. So I've been experimenting with this. I've been filing EAD and AP renewals earlier and earlier for people. So I had my most recent one that got approved. I filed it, I think, back in February. And this was for EAD AP expiring in December of 2023. And both of them got approved already. So processing times, if you file super early, seem to be really fast. I've been getting approvals in 2 to 3 months all of a sudden. The downs, so I've not had any RFEs asking why I'm filing so early. I've never had a rejection saying you filed too early. The biggest issue that comes up with filing early, so in my cases, the effective date of the new EAD AP card is the date of approval, not the date that the current card is expiring. So you're losing a little bit of time on the renewal because normally it would have been renewed from December 2023 to December 2025. Instead, I got it approved from May 2023 to May 2025. But I think that is much better than the opposite problem of potentially being stranded and not being able to travel anywhere because you're waiting for your AP to come through. So far, I've not had any negative results of filing the EAD and AP renewals early, even up to a year in advance.
There's a lot of rumors going on with regards to how many days it's going to take for the priority date to become current. Most probably for the Indian nationals, if they're applying right now, if everything remains as it is, it's going to take forever or they won't get the green card. I mean, that's how the things are. So a lot of people are asking the question, Emily, if I'm not going to get the green card, why do we have to feed you in paying money to legal fees for PERM application? Somebody has to pay, not the individual, but somebody has to pay. And why do we have to pay the money for the I-140 to you, Emily?
Yeah, I mean, the whole purpose of that is ultimately to be able to get H-1B extensions beyond the 6-year limit. So if you are in H-1B status and you decide, I know I'm never going to get the green card, I'm not even going to try the PERM process. Well, once you hit 6 years, you don't get to extend your H-1B anymore. And the only time to get back on H-1B is after you've spent an entire year outside the US and you have to go through the lottery all over again, which the lottery now is much different than it was for people 6 years ago. The chances of selection are very, very low. So for that reason, to be able to have those continued H-1B extensions, it's critical to have that labor certification filed before you hit your 5th year, so that you can get through the PERM and I-140 process in time to get the 3-year extensions, or at least so that your PERM has been pending for 365 days before you hit your 6-year limit, so that you can get a 1-year extension in that situation in case your PERM is audited or delayed or longer processing times. So yeah, it may be for something that you never actually get in the long run, but in the short run, it does give you the ability to continue to stay and work in the U.S. It also gives you the opportunity to leave the U.S. for some time and come back in the future without having to go through the lottery again.
And don't forget that if your spouse need to get the H-4 EAD, which is easily available, no qualifications required for your spouse, that's only possible if you have an I-140 approval, or if you're in the 7th year. There are some very rare exceptions, but yeah, if your I-140 is approved, then you will be. So please don't try to file the green card in the last year. Try to file as early as possible. First, you will get the priority date earlier. Second, you will not be in a hurry at a later time to sacrifice your future, especially when your labor certification is stuck somewhere. Third is that you have the H-4 EAD option if you get the I-140 approval early. There are other factors that I want you to remind that Long time ago, it used to take about maybe 6 months to 8 months for us to get the entire labor certification approval. Right now, the time that's taken is anywhere between one and a half to 2 years for a labor certification. If we go through the entire process of recruitment, prevailing wage, recruitment, filing labor certification, getting it approved, and I-140 approved, it may take 1.5 to 2 years if everything goes perfectly, though. Now, assuming you even file the premium processing of the I-140. Now, there are some exceptions available, especially if the company has some advertisements, you can cut down the process. Especially for the people who are working for bigger and larger companies, they go through the entire process again. The process will take anywhere for the bigger companies will be 2 to 2.5 years. So if you start working on the PERM labor certification early, though, in the first year of the H-1B, you will be in a much better position rather than contacting the company and working on it in the last 2 years. Please work on it. You have, even though green card, you may not get the green card, but you have these additional benefits of extending it beyond 6 years and also suppose getting the EAD if you have an I-140 approval. Anything else, Emily, before we go to the questions?
Nope, I think we can move on. Let's see. Angel Perry says, I'm on H-1B, also have the GC EAD with company A, and I want to change to employer B using the EAD. Who submits the 485J? Is it the new employer or the old employer? The 485J is submitted by the company that is now supporting your 485. So if your company A is the one that filed your labor certification and your I-140 and you filed the 485 based on that, they would have filed a supplement J already with your 485 unless it was an I-140 concurrently filed with the 485. If you are now moving to company B and are no longer going to be associated with company A, then when an RFE comes or when you get called in for an interview and it's time to submit the supplement J, your company B would be signing that, confirming that they've offered you a job that's similar to what you were originally sponsored for. So that's basically taking the green card process with you to the new employer if you're no longer planning on working with company A.
Anil Kumar Indoria has this question. Amit Kumar Indoria has this question from YouTube. My EAD has 14 months left. Now my spouse is filing for H-1B transfer. Can I file for my EAD along with the H-1B and H-4 premium processing? Yes, absolutely you can. You should file it right now. You don't have to wait for the 6 months. We have tried it so many times. Not a single time we ever got an RFE or ever got a denial because you filed the EAD earlier than 6 months, especially when you're filing with the H-1B and the H-4 together. If you file it, absolutely not a problem.
Mazar is on F1 and the spouse is, has an EB2 I140 pending working for her employer. Mazar also has the EAD based on that as well and wants to continue to maintain F1 status, but says, I want to use the EAD. What can I do? So because the F1 only allows you to work if you've been approved for CPT or OPT or STEM OPT after you graduate, if you use the green card EAD, you will be violating your F1 status. So you will go out of F1 status. You can continue to stay in the US and be in adjustment of status, can continue to go to school and also work, even though you're no longer in F1 status. So it's one or the other. You definitely can't do both. If you want to continue your F1 for whatever reason, you cannot use that GC EAD.
Question from Madhu. Can we complain against the employer if they are not willing to pay the final month paycheck after the H-1B transfer to another company? Absolutely, you can. Madhu, there are two ways, though, to complain for this company. One is the web link that we have given. There is another thing I want you to note it down, what I'm speaking about. It's called WH-4 form. You can file a complaint against the Department of Labor. What I strongly recommend is that when you ask for the, I've been told that some of the bad companies don't give the last month paycheck, Emily. That's very surprising. If they don't, you have an easy way out. Is fill a thing called a WH-4 form, send it to the employer, hey, give my salary, otherwise I'm going to send this complaint to the Department of Labor. Believe me, they will come to you and pay. 90% of the time, they will come and pay to you. If not, complain to the Department of Labor. That's better. Why not complain to the Department of Labor is that sometimes when you complain, though, the Department of Labor can go and see what all the practices they do. They can close the entire company down, and then to collect the money for you may become difficult, though. That's the reason why you don't want to kill and then get the money. You might as well get the money, and then it's up to you if you want to kill afterwards. So get the money first, and then you decide to complain, you can complain afterwards. So send a threatening them, hey, here is a W-4 form, pay me the salary for the ones that you did not. And it's very easy to get the money, though. Ashwin is asking this question. Can we complain against the employer preemptively without knowing the employer? The answer is no, that's fraud. If you don't know the employer is committing anything wrong, you can't complain against the employer. You should not. It's a fraud on you because you can't give a wrong information about a company to the government officials. If you know it is true that they're committing fraud, you should complain. But if you don't know anything about the company, don't complain. Please do not complain. That'll be considered, they may take an action against you. The company can sue you. The USCIS may also take action against you because if you file a wrong complaint, if you know that they have done wrong things, you should complain. Otherwise, you should not complain about a company.
RV has an I-140 approved and lost his job and wants to know if it's possible to still file for the change of status to B1, B2 if you're unable to get the new employer within 60 days. It is still possible to file it. Yes, having an approved I-140 is some evidence of your immigrant intent, but it's not the only factor. And I've really not seen in these job loss situations USCIS questioning how it is that you have an I-140 approved and you are not an intending immigrant at this time. I think USCIS kind of understands the reason why you're filing the B2, and even though you have a long-term intent to immigrate based on the approved I-140, that doesn't mean your intent today is to immigrate permanently, because you really can't. You don't have the job offer and you don't have the priority date that's current. So we've not seen an issue with that.
Arnav has this question that he has 2 I-140 approvals, and the USCIS is taking the latest I-140 approval priority date. First thing, Arnav, is that I don't know why the latest one didn't have the old priority date. That's one thing that I want to understand it. But if you think so that they're wrongly considering the priority date as the latest, the recent one, not the old one, you can write a letter to the USCIS, which we know that they're not going to care about it. But you can make an attempt. If that fails, though, you can always sue the USCIS, take them to court. Some of these things, taking court is not that hard. I mean, you just take them to the court, you explain to the judge that, look, my priority date is 2011, but they're only considering in 2014. Normally, do we think so the judge will look into it? No, the judge won't look into it. When we file the court case, we serve it to the USCIS. The USCIS at that point of time will take the case more seriously. Wow, this is a court case. There seems to be something wrong with us. Let's look into the details more thoroughly, though. It gives an occasion. If something is not approvable, if we go to the court, will we get it approved? Most probably not. But if it's something and obviously a wrong thing done by the USCIS, the best way to get attention is to go to the federal court, file a court case, and then serve the notice to the USCIS. Then they will look into seriously. Back a long time ago, when I started practicing, Emily, we used to just threaten the USCIS, hey, buddy, we're going to sue you if you don't look into the details what we are providing. And they used to look into the details at that point of time. I was in the committee for the USCIS, for the ALA committee, and the lawyer used to say, please don't sue us. First, let me know you're suing so that I may be able to resolve your issues. But that failed later on. Then later on, what we used to do, Emily, is that we used to send a draft of the court case that we are going to file to the USCIS lawyer, and the USCIS lawyer used to respond to that. They stopped doing that. Then now we come to the stage only is that just sue the USCIS and then serve the notice, because if they don't respond to it, the court will give a default judgment in favor of us. Of course, they will respond to it. But so definitely we have to, if there is something that the USCIS is not paying attention, which is obviously very wrong done by them, the best source to get their attention is obviously filing a court case and serving them the notice that, hey, you've been sued because you're not looking at the application properly.
Ramachandra says, we're on STEM OPT and running out of time. How can USCIS address the injustice to the people who applied only once in the lottery through a legitimate employer? Yeah, that is a tough problem. There's so many people that this was their last year of their STEM OPT time and they didn't get selected because of all these fraud applications that USCIS included in the lottery. Why did they not kick them out before they ran the lottery? I don't know.
Why not this year? They don't kick them out this year.
Why not what?
Why not kick them out this year?
Right. Yeah. I don't know why they didn't do that, because they've obviously figured it out what they're doing. So we can hope that there'll be a second lottery that would happen after June 30th, once we know how many petitions were actually legitimately filed. I saw the idea floated earlier today about DHS having the authority to issue a one-time OPT extension for people who were submitted in this year's lottery and were not selected. They've definitely done emergency cap gap extensions before. That's kind of what initially created the cap gap idea. And then ultimately that's what created the first STEM OPT extension, was because of these problems with the lottery and people not being selected or not having their cases processed and their OPT time was running out. So if a campaign to do that was started and gained enough steam in time, maybe that's something the Biden administration could do, because it doesn't require Congress. All of that STEM OPT extensions that were created initially was all based on DHS authority. None of that went through Congress. The 24-month STEM extension didn't go through Congress. The 17-month STEM extension didn't. Cap gap didn't. It was all regulatory. They could issue an emergency interim final rule just to extend it for 1 year for people this year. I don't know if they would actually do that, but that's not a bad idea to start trying to gain some traction on it.
Is it the proposal you are making it, Emily, or is it the proposal Department of USCIS is making it?
Neither. This was something that came across my Twitter feed earlier today. And I thought, that would be one way to potentially at least help the people, because they've obviously addressed that. They know this is a problem now, and it hasn't gone away. They've been trying to sweep it under the rug for the past 3 years. They finally come out and said, okay, we have a problem. 400,000 registrations were fraud. And that's caused so many people to not be selected. Maybe that's something we can start a campaign for.
Okay, definitely that's a good idea. I will try to draft a letter to the USCIS to consider the people giving EADs for the people who have only applied one time H-1B, not for the people who have applied for multiple H-1Bs. That's a good proposal. I will try to draft a thing and will come up next week. Emily, one other thing that was discussed between me and Stephen, and we wanted you to be included, I don't know if Stephen made you aware was that, Emily, is that why not sue the USCIS in the class action? You knew about this fraud. There was a litigation about this fraud that was presented. You said you are going to prevent that last year. All that you came up with as dumb statements by the employer, which they did not, especially the fraudulent guys, they did not adhere to, which we made, the lawsuit made you aware. And not only that you did not prevent it, you actually are giving the H-1B approval for them. you are actually not taking them out of the H-1B number. If you just don't give the H-1B approval, that would have gone to the single filers. If you are giving the H-1B approval to the fraudulent people, you're also taking it back when you're revoking the H-1B, because that guy who would have been on a student visa, you pulled him out of the student visa. Now you're revoking the H-1B. The guy will be neither F1 nor H-1B, and then he'll be hit with a misrepresentation. Had you taken the action 3 years ago, and would have prevented it much better than what you're doing right now. And still today, when you're telling that there are 90,000 people who have filed 400,000 applications, you're still considering them and giving them the H-1B. And this is something that you're only trying to take off the 85,000 H-1B numbers that are available. That's the whole purpose seems to be, instead of giving it to the people who deserves it. Can we do a class action on it, Emily?
I think it's definitely something to consider. And another point to add to that is when USCIS revokes an H-1B for fraud, they say that you're no longer counted in the cap.
Yes.
Okay. On top of that, that cap number is supposed to, by law, go back into the pool for the current year. I guarantee you they never do that, because how are they keeping track of these revoked H-1Bs when the lottery is already done and they've already selected everybody? For last year's H-1Bs that are being revoked now, you're telling me they're adding those numbers to this year's lottery cap, but they already ran the lottery? How are they even doing that? It's not, they're not following their own regulations. And clearly their system of preventing fraud is not working. I think it's definitely something for us to look into.
Ramchandra Reddy is asking the same lines, the questions which we were discussing in our staff meetings. He's asking the question, are you seeing more notice of intent to deny? Are you seeing more notice of intent to revoke? Let me answer the question to you, Mr. Ramchandra. We are seeing both, but here is the problem though. For the people who are applying for the H-1B transfer or extension or amendment, we are seeing the notice of intent to deny. That means that these people are already counted towards the H-1B number. We are seeing the notice of intent to deny. We are not seeing the notice of intent to deny, not that much. For the initial H-1B application that has been filed with the USCIS. So Ramchandra, you're right that even though they have knowledge about this particular duplicate application, multiple filing applications, they are still approving it and then denying it when they are transferring it to the other companies. So now, of course, we're also seeing a notice of intent to revoke applications. That is happening after, notice of intent to revoke is happening after the approval. So if they would have denied the initial application, they wouldn't have been counted toward the H-1B number. Everything would have been fine. But if they're denying the extensions, transfers at a later date, they're already been counted. So definitely this is a big problem. I know, I mean, you're saying that you have 500 folks who are willing to pay. We're considering, there are a lot of other things we have to consider, Mr. Ramchandra. There are certain things we may not be able to take money from other people. We may have to sue it and then get the money from the USCIS itself. Like the last time we got, we got success in the class action when we sued for the H-4 EAD. We are seriously considering it. If there is any money thing, we may look into forward to see if we can collect any money. If it's legally allowed for us to do for the class action, we'll also come to you guys to collect the money. But that's something that we are considering very seriously. We will keep you informed about it.
Srujan says, I recently lost my job on H-1B, but applied for the 485 in the EB1A category and have those receipt notices. Will those help me stay beyond the 60-day grace period, or do we recommend moving into H-4 and applying for the H-4 EAD? I think I would, well, number one, I would ask, is your I-140 already approved, or did you file it concurrently with the 485? If it's concurrently filed, then there's a chance, what if your I-140 ends up getting denied? Then your 485 will be denied. Now you have no backup status if you don't proceed with an H-4. The other issue is, even if your I-140 is already approved and it's relatively safe for you to rely on your 485, in your situation, If you don't go for the H4 and the H4 EAD, you're going to be waiting, 6, 8, 10, 12 months to get your GC EAD. And what happens if you get a job in the meantime? Well, you're no longer in H1 status. You're beyond your 60-day grace period, so you can't get back into H1. You can't now file for the H4 and the H4 EAD. So for that reason, it may be beneficial for you to go ahead and file those just in case, so that you don't have to wait forever to get the EAD based on your 485.
The question that comes from Ramesh Kumar from Facebook, is the PERM audit common? It's not common, but I think it's about 5 to 8% of the PERM cases get audited. So I don't know if it's 15% or 7% or 8%. Is it common or not common? It's up to you to determine. But not, according to me, it's not common. But just because you got an audit of the PERM, don't be worried about it. It's just, it normally gets approved, assuming that everything is okay. For our office, so what we do is when we file a labor certification, we already assume that it's going to get audited, and we prepare all the things ready though. Because what happens is that there are some records, phone records, all those things need to be kept before, because otherwise those records may get erased. People may change the companies of the long distance, the cell phone companies. So there may not be records. So we normally keep audit ready when we file the labor certification. So most of the lawyers do. So it's there 5 to 7% of the time, not much to worry about it.
Arun says, I have an EB2 I-140 approval. Is it okay to port my EB2 to EB1C? I got a managerial role with a pay hike. What are the advantages of the risks or the risks? So certainly it's a good idea to do that, assuming that you qualify for the EB1C category, because you do get to port your priority date. And the EB1 visa bulletin priority dates are much further forward than the EB2, so you would likely get a green card much quicker if you're able to do that. But be aware that it's not just getting your US job into a managerial role. You had to have worked for that company outside the US for at least 1 year before in a managerial role as well. So if you've never worked for the company outside the US, or when you did work for the company outside the US, it wasn't in a managerial role, you don't qualify yet, even though you've been promoted into the managerial role into the US. So for some people to make this work, they actually have to exit the US, work for the company abroad for a year in a managerial role, and then come back to qualify for the EB1C. And more people are doing that these days, because obviously EB2 and EB3 is so backlogged, and it should provide a much faster green card, but you've got to make sure that both positions abroad and in the US qualify as manager. Just because the job title is manager doesn't mean it qualifies as manager. They want to see the breakdown of the job duties that you're spending the majority of your time managing people, doing performance reviews, having one-on-one meetings, giving feedback, setting policies, and those kinds of things, not being like a project manager or something like that. So there are definitely different shades of what is a manager. So you want to get that assessed before you take the jump to make sure that you're even going to qualify after you spend a year abroad.
Hemchand has this question: is it allowed to work for a new employer in severance period? That means that you have been terminated the job, but they're paying you the salary. Can you work for a different company? I'm assuming that the second company filed the H-1B. The answer is simply yes, you can. In the severance period, you can work with the second company. Absolutely nothing wrong with it.
Shantanu says the I-140 was filed in premium processing more than 15 days ago, waiting for the paper receipt notice, and the attorney is not providing the status. How can I check the I-140 status? Is there anything online? So in addition to the paper notice that's sent by mail, there's an email notification that is usually sent to whatever email address is listed on either the 907 application form or the G28. So they should have received an email notification. The email does not have the receipt notice in it, but it does have a receipt number on it. But if the employer or the attorney is not providing that to you, you don't have the authority to contact USCIS to get it yourself because you're the beneficiary of the I-140. Only the petitioning company or the attorney can contact USCIS about that case. So unfortunately, you'll just have to wait until they provide you that information. And you can later submit a Freedom of Information Act request to get a copy of your I-140 filing in case you need that in the future.
Abhijit has this question. My wife has returned on advance parole and her passport was marked as parolee with expiry date in 1 year. Does this expiry date has any significance? Do I need to leave the country within that period of 1 year? The answer is it has no significance at all. You can ignore the expiry date only this time. Please don't apply this to anything else. When you're coming in advance parole, they will give an expiration date. You can ignore it. You don't have to act on that. You can only look into the advance parole expiration date, and you need to file an extension before that. You can ignore what's the online expiration date is.
Our case says, I see the last 4 years of the data from USCIS about those duplicate filings on their website. Have they been taking any action over these last 4 years? Yes, they have. We started seeing probably in 2021 some notices of intent to revoke from 2020 filings. And then last year, we started seeing them for 2021 filings. And now this year, we're currently seeing them for 2022 filings. So it used to be whenever intent to revoke was issued, a lot of times it was for an H-1B that was almost getting ready to expire or even already has expired, even up to 6 years ago. We were seeing that long of a gap between the time the H-1B was approved and the time the notice of intent to revoke was issued. That time frame has shortened every year. So now I'm hopeful that USCIS will be issuing notices of intent to deny and denying these duplicates that are filing the petitions rather than approving them and going back next year to issue the notice of intent to revoke. But we're too soon in this year's CAP season to have seen any results of H-1B filings. So yes, they have been taking action on those. We've been warning people about this risk for the last, I don't know how many years, even before the electronic registration. We were telling people don't do duplicate filing even under the old system, and everyone thought we were crazy. But it's because we see these notice of intent to revoke. We, when an employee gets one or an employer gets one, they're not sharing that with all of their friends and family. They keep it to themselves. They do share it with attorneys. They can figure out how to resolve the situation, but no one's going around publicly saying, hey, I did this and now I got this notice of intent to revoke. Because everyone's keeping quiet and USCIS has kept quiet about it, everyone kept doing it and it's just gotten worse and worse. So hopefully now with this announcement this year, we'll see more action and more action earlier. And maybe that'll help some people that were legitimate filers that didn't get picked.
Question from Piyush with regards to the USA Citizen Act of 2023. Is it something that seems to be some possible? Is it going to be passed, or what are your expectations on it? No, it doesn't look like it has any hope. It has too broad of the provisions to give green cards to almost a lot of people who are present in this country for a lot of period of time. We don't see that it's only one-sided. Only Democrats are supporting it. Republican parties, people are not behind it. And the Democratic Party doesn't have a majority in House. In the Senate, they have only 50-51. They need actually 60 votes to pass anything there in the Senate. They don't have that. So it's very unlikely at this point of time to rely on that USA Citizen Act of 2023.
Praveen says an I-290B motion to reopen or reconsider was dismissed without prejudice after the 485 was denied for some ineligibility. But the I-485 was an EB3 filed concurrent, and the denial was actually in error. So he wants to know what are the options after the I-290B dismissal. we are seeing USCIS make some really bad decisions that are completely wrong, and we're having to file these 290Bs. And we have come across cases where USCIS just says, we don't care. You didn't meet the standard of getting this case reopened, even though it's so clear that the denial was an error. So we do normally work with the Ombudsman Office to help with those. It's the DHS 7001 form that can be filed online. It does take a very long time. There are probably 5-6 weeks at a minimum just to get an initial response from them, letting them know that they're taking up the case, because they're so inundated with stupid things USCIS has been doing that they're taking the truly urgent and life-threatening kind of situations first and leaving all the other issues to take longer. But beyond that, we're starting to file lawsuits. So we're about to file or have just filed. We've got one in process that is close to filing or just been filed for this exact scenario. So you can definitely reach out to us or Stephen Brown in our office to share the details of what exactly was the issue in your case, how was it a clear error, and see if maybe litigation might be the route to go.
RV is asking the question, is there any recent success in compelling circumstances EAD after job loss if the I-140 is approved? Of course, compelling circumstances is only for after your I-140 is approved. I would rather say I've never seen a denial recently for the compelling circumstances EAD. Because normally we do file compelling circumstances EAD. Only when we get any denial, it comes to my notice. Otherwise, I don't get to hear about it in my office when something gets approved. Yeah, I've seen some of the cases, especially the person, I-140 lawyer for our office is Ryan Wick. He works on I-140 compelling circumstances EAD. We haven't had any denial recently, though. However, though, it's taking about 8 months to 10 months to get the compelling circumstances EAD approval, especially recently with the tweet of USCIS where they are telling that if you apply for the B2, you can change the status from B2 to H1 even before the B2 is approved. That tweet is really a good news or a bad news, depends on, because after that tweet came in, we are not encouraging people to apply for the compelling circumstances EAD. The reason is that once you apply for the compelling circumstances EAD, you don't apply for any, and then you are over the 60 days. You cannot change from compelling circumstances EAD pending to the H-1B. You cannot. You have to go outside the country and come back in, and most of the people will require stamping before they come back in. So that's an extra burden that the people have that they have to bear. So they may be a little bit more comfortable in moving to B2 rather than compelling circumstances EAD. But yes, we did file a lot of compelling circumstances EAD. We haven't got any denial at all in the recent months. Just because we never got a denial doesn't mean it's a guarantee that everybody is going to get an approval. It's not. Past results are not a guarantee for the future results.
Shailesh says the PERM was filed in May 2022, and his employer said they received an RFE a couple of months ago, and the attorney responded. He's not sure what was the RFE and how long is it going to take to get a response from USCIS. Okay, so if this is the PERM, it would have been an audit rather than a request for evidence. And right now, and this case is at the Department of Labor rather than USCIS. So the processing times are available on the DOL's website, and they're currently working on audited cases that were filed in April 2022. This was not the last updated April 30th, so the data's not that old. So it might be another month or so for them to look into your audit on your case and issue a decision.
Rema has this question. Site visit was been scheduled by USCIS for a job amendment petition, which was already approved. While filing, I was on Project A. And by the time it's approved, I was on Project B over a month. Any issues? First of all, if you are in the same location, though, the project may or may not be that important, though. However, I want to be careful on this FDNS, though. Some of these officers are very rude. They don't understand the logic of it, that the project is not important. It's the location that is important and the similar kind of job. So since you are are working in the same geographical area, the intended geographical area as when you petition, I don't see any problem in speaking with the officer. But one thing with these officers is that they have been very pushy and trying to ask questions that are unnecessary, not related to it. If you ever feel anytime any uncomfortableness with regards to that, tell them, I do not want to cooperate anymore. You can conclude this meeting, it is over. And you can tell them on their face, tell them that according to their website of USCIS, it is voluntary for you to participate in the FDNS. It is not compulsory, hence why you are opting out to not cooperate with USCIS, not give the information what they're asking. I normally would like to cooperate a little bit to see if the officer is nice, then I would cooperate. But if the officer has been very rude and trying to intimidate, give me all your pay stuff from the time you came into the United States. Give me the income tax returns for every time. Then I will tell him, I'm sorry, there are some bad words, but I don't use it against them. I don't want to use it on YouTube, but I tell to myself that I would say that, but I wouldn't say it. I would just tell that, no, I'm not going to cooperate. I don't need to, according to your website. You can conclude it. You can say that thing, and you can cite the website of the USCIS to them. So as long as the officer is good, you're good. We always tell that in the FDNS visit, it should be your way or highway. Simply, your way or highway. If the officer exceeds a little bit, you warn him, hey, if you are going to only ask specific question, I'm going to answer it. If you're going to exceed it, I am not going to cooperate. You can tell it. And if the officer will stick to that questions, then you can answer. If you ask any more questions, you don't have to cooperate.
Swaminathan says, is the TN visa extendable infinitely? Would you be able to climb the entire corporate ladder on a TN visa? So the TN for Canadian or Mexican citizens does not have a 6-year limit or a 5 or 7 year limit like the H-1B or the L. So in theory, yes, it can be extended over and over again, but it also is a non-immigrant visa that does not allow for dual intent, which means that every time you're extending that TN, you have to establish that you have a residence abroad outside the US that you have no intention of abandoning. So what we often see is once you hit 6 years in TN status, when you file that next extension, we always see a request for evidence asking for proof that you have that residence abroad that you've not abandoned. And then you keep getting those RFEs. And then the other issue is by climbing the corporate ladder, the TN is not available for every type of job opportunity. There's actually a set list of occupations that are allowed for the TN. So as you're going up that corporate ladder, you have to make sure that each job you're taking is still on that TN list. Now, for some roles where you are maybe an engineer and you're moving into a supervisory, a managerial role as an engineer, that can still qualify as the engineer category, even though you're managing, because you're managing engineers and you're using those same skills. But if you're moving into a president or something like that, you'd really have to look and see, is there any potential category that this TN will fit under for that particular job. So it may not be possible to stay on it forever, going up higher and higher into the company structure.
Jennifer got an I-140 approval in 2017, got promotion last year. She's thinking, she has refused it because she's thinking that it's going to complicate the I-140. First thing is that a natural promotion should not interfere into getting the green card based on the I-140. So, but however, we have seen some of the companies interpreting otherwise. Most of the companies like FAANG companies, Facebook, Google, Apple, Tesla, and all those companies with natural promotion, they're perfectly fine. The USCIS is fine. The Department of Labor is fine. But there are some companies that say, no, you can't do that. I don't know where they came up with the rule. If it's a natural promotion, that's fine. So if you're a software, you're a senior software or so, that's perfectly all right. But if you're a software engineer and then you want to become a lawyer, that's definitely not a normal promotion. It's a completely different field. But check with your lawyers why it's not acceptable, because Reddy Neumann PC is saying that it's a natural promotion. The other reason, Jennifer, I will take the promotion is that if you are from India, if your prior date is 2017, it may take a long time for you to become current. So I don't want to lose the opportunity of your career progression because of something that may or may not happen. So I would take the opportunity of accepting the promotion, even if the company says, well, we're not going to file the green card 485 if you accept the promotion.
Ram Infinity says, is it possible to extend the period of a B2 visitor to beyond 6 months? So yeah, it can be possible, but there are a lot of tricks and twists when you've got multiple applications pending. We dealt with this a lot under the old policy that required someone who was waiting for their change of status to F1 to be approved, and USCIS was requiring these bridge B2 applications to be filed in between because the processing times of everything were so long, and they're still terribly long. So what ended up happening with a lot of these is you file the initial B2 requesting 6 months, and then that 6-month stay is coming and your F1 is still not approved. We would have to file another B2 extension for the next 6 months and hope that the F1 would be approved in time. But then USCIS would get all out of whack and they would somehow approve the second B2, but by the time you got the approval notice, it's already expired. And then because of that, they deny the F1, and then the first B2 is still pending. They just can't, the right hand doesn't know what the left hand is doing when you have these multiple filings. There are a lot of things that can go wrong. So is it possible? Yes, but it has to be done very carefully and monitored closely, and there's a lot of chances for it to go wrong very easily through no fault of the applicant. It's just the way USCIS is, unfortunately.
Priyanka has an I-131 approved, but she hasn't received it, but she has a H-4 stamped in the passport. Can I travel internationally? Assuming that your husband is maintaining the H-1B status and working for the same company, working for a company on the H-1B, I don't see any problem for whatsoever at all for you to travel on H-4. It's already stamped in the passport, so you can travel. It will not interfere into the advance parole or EAD, which is already approved for you. So it is not going to make any difference. You can travel, Priyanka. I don't see any problem in it at all.
Vinod Kumar says, will my I-140 be affected if my company files an H-1B amendment for a location change for the same role? I'm in my 7th year. And my I-140 has only been approved for 3 months. Well, it all depends on whether this location change is temporary or permanent. So if the permanent role will continue to remain at the original location and you are just temporarily moving to a different location and tend to go back to the old location by the time you get your green card, it has zero impact on your I-140. Now, if the job is actually moving to a new location and that was not contemplated on the labor certification, so that the labor market was not tested in this new location, and there's no chance of you going back to the old location, let's say that company is shutting down that location or something like that, it doesn't impact the already approved I-140, but you very well may have to go through the PERM and I-140 process again to have the labor market tested in the new work location. So that I-140 remains approved for you to be able to keep extending your H-1B beyond the 6-year limit, but you may not be able to file the 485 when your date finally becomes current, depending on the exact scenario of the location change.
Question from HF. I came back to United States on advance parole at the time the advance parole was filed with the company A's I-140. Now I'm working for company B. Would that be an issue? Absolutely not an issue at all. Advance parole is given to you. The EAD and advance parole is given to you. It's not given to your company. So you can travel on advance parole on company A, and when you come back, if you have an EAD or any other work permit like H-1B, you can work for company B. Absolutely not a problem. I don't see any problem in it at all.
All right, well, I think we are out of time for today. Thank you everyone for joining us. And don't forget that we do have a daily conference call where you can join in on Zoom and get your questions answered as well. And don't forget to subscribe to our newsletter by going to rnlawgroup.com.
Thank you very much.